An issue we're faced with in Florida divorce cases and Florida paternity cases, oftentimes when there's minor children, are parental relocation cases. And I haven't practiced these cases in other states. I don't know if they're more prevalent in Florida or not, but they're pretty prevalent in our practice. And the reason is, in my opinion, is we have a high percentage compared to other states of folks who have relocated down to Florida, oftentimes leaving friends and family and extended family and support networks back in other states. So it's not uncommon for folks to come into our office and say, look, I want to relocate back up to New York, I want to relocate to Boston, I want to relocate to Chicago or wherever. And the reason is often because they have a big family network up there and they don't have much for family down in Florida. So there's always an easy way and a difficult way to do parental relocation in Florida, and it's provided for under our statute. And just to illustrate that how particular parental relocation is in Florida, we have an entire statute that is very extensive. It's very procedural. There are clear requirements as to what you need to do, both procedurally and substantively, how you need to plead, what type of font you have to use in components of your pleading. So it just goes to show you how particular the legislature is on this particular component and how important they feel it is to go through the steps required. Usually when you have an extensive amount of procedure, it's because the legislature feels that there's a high level of due process required for that particular issue. So why do we have so much for parental relocation? Well, because it's a major issue. It's really the issue of relocating a child, far away from one of the parents, and it may be 51 miles away from the other parent, or it may be 5,000 miles away. But most often it's several states away is the issue, and that's really what's going on. So under our parental relocation statute, there is a number of different factors that the court must consider. There's no presumption for or against parental relocation. However, if you don't follow the procedure, you can be barred from relocating altogether, and it can be fatal to your case. So when you do go through, if you do have parental relocation issues in your case, and that means either you're seeking to relocate or the other parent of your child or children is seeking to relocate, it's very important that you really find an attorney that's familiar with this area of practice. There are a number of different issues under our statute that provides for whether a relocation is appropriate or not. But ultimately, and those factors include its own set just for parental relocation, and it also considers explicitly all the factors in determining what the best interests of the child are for a time-sharing plan. So there's a lot of discretion established for the courts in determining whether relocation is appropriate or not. We have plenty of we have plenty of case law that's established when judges have gone beyond their discretion. And there are a few kind of typical ways that happens. One, a prospective relocation order is reversible error. That's been established time and time again in Florida. And what does that mean? That means the determination of whether a relocation is appropriate is made now. It's made in the present. It's not made an order saying, for instance, that a relocation is not appropriate now, but it is appropriate 3 years from now. Is reversible. So that's an issue that's come up several times. There's a recent case out of the 5th District that, and you can go to our blog and you can see the case law and our comments on all of this, and these other cases on parental relocation and everything related to family laws they come out. But that particular case essentially laid out that a spouse made her diligent efforts and established that it was in the child's best interest, and established that it was appropriate and the right thing for the judge to order the relocation out to California based on a number of circumstances, including not just what was in the present, but what had kind of led up to that situation. It's an important case. Check out our blog and read about it. But it's a relocation that was denied on the trial court and then reversed and allowed on remand. So very interesting.